Hello, good morning everybody and welcome to our GDPR webinar for businesses this morning. My name is Laura Murphy and this morning I'm joined by my colleague Jennifer Huzzy. Hopefully you can all hear us loud and clear and see our screen perfectly. Lovely. So just to kind of clarify a few things before we start, we are recording this morning's webinar, so you will receive a copy of the recording plus the slides later on today or early tomorrow, but hopefully later on today. So we've set out the agenda here for you, and GDPR, it's certainly the buzz term at the moment, and that's certainly for good reason. The scope and the impact of GDPR can really not be overstated, and it will affect most, if not all, areas of businesses, and it will change how you manage your personal data forever. So today we're looking at GDPR from an employer's perspective, and we're looking to peel back the layers of legislation and the massive reading material that's out there on GDPR, because there really is a lot and you could certainly tie yourself up in knots trying to make sense of it. But today we're going to give a quick overview of GDPR. We're going to look at the key changes in the legislation, then we'll go into some detail on how you can start preparing, and we'll look at BrightPay as well. So there's a lot of content to get through, so we'll get going. And just also we will have a Q&A session at the end, and we always find that's an interesting section, but please do type your questions as you think of them, and we'll get to them at the end. Okay, so to start off, what is GDPR? GDPR stands for the General Data Protection Regulation. The GDPR is a European privacy regulation, and it replaces all existing data protection regulations. It's an extremely significant piece of legislation, and as I said earlier, it will change how you manage personal data. I suppose the ultimate objective of the GDPR is to provide better protection for personal data. So in terms of business, previously data was seen as an asset, really, whether you had long marketing mailing lists or competitors' details, but certainly in today's world it's seen as a liability with significant risk attached to retaining data. The current piece of legislation in relation to data protection in the UK dates back to 1998, so that certainly predates current levels of internet usage, cloud technology, so it really is unsuitable for today's digital economy. So certainly modernisation was required or needed, but that's not to say it's given a bit of a headache to some small employers who are trying to get their heads around it as well.
Okay, so as Laura said there, the GDPR, it's coming into effect on the 25th of May of this year. This is the day the legislation actually comes into force. So it is vital to remember this is the day you must be compliant by. Now, realistically, at this stage, we've pretty much less than 3 months. So if you haven't started to prepare, now is certainly the time to do it. Don't leave it until the 25th of May, because at that stage, you're going to be in breach. Okay, there's a lot of reasons employers need to sit up and take a notice of the new regulations, and that comes in the form one of rather significant fines. So organisations can be fined up to 4% of annual global turnover for breaching GDPR, or 20 million euro, whichever is higher. Now, this is the maximum fine that can be imposed for the most serious infringements, so the likes of not having sufficient customer consent to process the data or violating the core privacy by design concepts. There is, however, a tiered approach to those fines. So a company can be fined 2% for not having their records in order, as per Article 28, or not notifying the supervising authority and the data subject about a breach, or not conducting impact assessments, and we'll look at those a little later on. And just to note that in the case of repeat offenders, the penalties can be cumulative and really quite likely to be punitive as well.
Perfect. And just in addition then to the big fines, individuals can now take data controllers and processors to court to claim compensation for material loss and non-material damage. So this means compensation for distress, hurt of feelings, reputational damage, even if they didn't have a financial loss. So if you've had a GDPR breach on top of the fines that Jenny has just talked about, you may see that you could be faced with a civil case as well with additional fines.
Absolutely. And then there's other factors you need to take into account. You've got the likes of brand damage, and it is reported that the breaches are going to be publicised. So that's a very real factor for the SMEs out there. And your loss of business, cost of investigation, and the likes of litigation as well are going to be, other factors to take into consideration.
Okay, so we don't mean to scare you overly, but it would be wrong of us not to talk about the fines here as well. But it is believed that fines under the GDPR, they will be proportionate and may not even be issued in every case. So certainly if you are able to demonstrate that you've taken steps towards compliance, then you will be able to hopefully mitigate against these fines. However, if you've buried your head in the sand and done nothing, then you will see that the ICO are coming down on you with large fines.
Okay, so who does the GDPR affect? It's going to affect EU establishments that process personal data. So regardless of whether the processing takes place in the EU, it's going to affect non-EU establishments who offer goods or services to individuals within the EU, irrespective of whether payment is required. So that could be the likes of your Facebook. And then also non-EU establishments who monitor individuals' behaviour that takes place within the EU. So Google being an example there. So it's not only European companies that are going to be affected by the GDPR, it really is going to have a global impact. And we've used the word establishment here just to let you know, it's not just companies that are going to be impacted by GDPR. It's sole traders, charitable organisations.
I think we had a question just one that came in earlier already about a church group. So absolutely, if a church group is holding personal data, the GDPR is going to apply to them as well.
That's it. You'll see it now as we go through the slides. Once you process personal data, the regulations are going to apply to you.
Yeah, and just very briefly, just to touch on Brexit, I just want to say that the GDPR of May, so obviously the UK will not have to part of the EU at that stage. So GDPR will apply in the UK from the 25th of May. And in addition to that, by all accounts, I think that the thought process is that we will have similar legislation even in the post-Brexit era, and the Queen actually even referred to that in her speech last June. So I think there's no reason to be again burying your head in the sand about GDPR. Okay, so as most of you will know, the supervising authority in the UK is the Information Commissioner's Office, the ICO. And there's also now a European Data Protection Board, so they oversee all the member states and bodies, but they'll also adjudicate on disputes if they're escalated as well. I have to say the ICO have an excellent resource in place to assist companies and bodies getting ready for GDPR. They've reams of information on their website. It really is excellent. And they've also got a new helpline specifically designed for small organizations in the light of GDPR. So we put the number up here. We've had reason to ring it ourselves on occasion, and I have to say it's a really excellent resource if you're looking to give them a call. And then just finally on the ICO, under GDPR, there is no requirement to register for GDPR. However, that said, there is a provision in the UK in the Digital Economy Act that it means it will remain a legal requirement for data controllers, so anybody processing data, to pay the ICO that data protection fee. I think for most small companies it's £35, so it's not massive, but you'll still need to continue going on to the ICO website and registering for that. Okay, so we've already used a few terms interchangeably, and I just want to clarify these terms before we go on any further. So firstly, the data subject. This is an individual who is the subject of personal data. So that might be your employees or your customers' data. Then we have the data controller. So the data controller controls the contents and the use of personal data. So that'll be you in most cases in your business or your organization. The processor is a person, public authority, agency, or other body which processes personal data on behalf of the controller. So if you are outsourcing something like your payroll, then your payroll bureau is going to be your data processor. The term processing means any operation which is performed on personal data. So processing could be storing data, it could be recording it, changing it, so it's not necessary that you're actually working on it. It could be something as simple as storing it as well. And then a personal data breach, again, we'll talk about breaches in more detail, but it means a breach of security leading to the accidental or unlawful destruction, loss, alteration, unauthorized disclosure of, or access to personal data. Perfect. So we want to move on now to the key changes to the data protection legislation in light of GDPR. GDPR extends a number of already familiar concepts and rules from existing data protection legislation, but we want to describe here the key changes that GDPR makes. So we've highlighted 10 key changes, and we'd like to go through each one of these now in more detail. So the first point that I want to look at is personal data. The definition of personal data is any information related to a natural person or a data subject that can be used directly or indirectly to identify the person. It can be anything from a name, a photograph, an email address, bank details, even an IP address, a computer IP address. And by no means is this an exhaustive list. So it's really anything that can be, as we said, used to directly or indirectly identify a person. So do you hold any of this type of information in your organization? Of course you do. Whether it's your clients, your customers, your employees, somewhere along the line you're going to be dealing with personal data, and the GDPR will apply to you.
Okay, the next one we want to look at then is special categories of data. So the definition of special categories of data would be sensitive personal data or sensitive data is extended by the GDPR, and this is adding to genetic and biometric data to this protected category. So under this expanded definition, the special protected categories extend to the processing of racial or ethnic origin, political opinions, religious or philosophical beliefs, even trade union membership, genetic biometric data for the purpose of uniquely identifying a natural person, data concerning the health, data concerning a natural person's sex life or sexual orientation. So in relation to, holding or processing any of those special categories of data, there's more onerous conditions that must be satisfied in order to legitimize the processing of that data. And in particular, you will need the likes of explicit consent from individuals if you plan on processing any of what we've just mentioned there.
Yeah, and just to pick up on one of the points, Jenny, that you've mentioned there, because it's one that we've had questions on our support lines as well, is the processing of biometric data. And this brings up an interesting point in relation to those employers who require their employees to clock in and clock out using finger or handprint. So finger or handprints will actually be considered as biometric data. So unless as an employer you're using a clock in, clock out system like this, unless you can really prove a legitimate argument that that processing this biometric data is for the vital interests of its employees or is in the public interest, then I think you're going to find it hard to legitimately, continue to record this data. So it's just to be aware of it, and we've had people ring in who do use it, and certainly at the moment we'd be saying, or well, once GDPR comes in, we'll be saying it should at least be optional if you're using fingerprint, clock in, clock out. Now, that said, the GDPR leaves scope for individual member states to make some small derogations, so we may or may not see a change to this in the future. But currently, as it stands, once the GDPR comes in, I'd have a few concerns about using clock in, clock out with fingerprints.
Absolutely. So we'll look at the principles of data protection now. So currently under data protection legislation, we have 8 principles. Now this has been reduced to 6, but certainly none of the content has been lost. If anything, it's been bulked up. So under GDPR, personal data shall be processed lawfully, fairly, and in a transparent manner, collected for specific, explicit, and legitimate purposes, and not further processed in a manner that is incompatible with those purposes. It has to be adequate, relevant, and limited to what is necessary in relation to the purposes for which it's processed. It has to be accurate and, where necessary, kept up to date. Every reasonable step must be seen to be taken to ensure that the personal data is inaccurate is erased or rectified without delay. It has to be kept in a form which permits identification of data subjects for no longer than what is necessary. And it shall be processed in a manner that ensures appropriate security of personal data. So this includes protection against unauthorized or unlawful processing, against accidental loss, destruction, or damage. So using appropriate technical or organizational measures. So really the overarching principle here is that of accountability. You need to be able to demonstrate compliance with these principles. And really what it's doing is it's putting an increased burden of proof on those people who now hold and process personal data for people.
Perfect. So we move on.
Okay, so if we look at the reasons why you can process data. So when you're reviewing the data that you process and you ask yourself, is it lawful for us to process this information? These are the points that you really need to be looking at. And if you're unable to tick off any of the boxes below, processing really should not be completed. So processing can be lawful if it is based on, one, the data subject has given consent. And we'll come back to the issue of consent a little later. It'll be lawful if it's necessary for the performance of a contract or to take steps prior to entering into a contract. So if you're providing your service, so if we look at the likes of retaining information on a hotel booking there, for example. It'll be lawful if it's necessary for the compliance with legal obligation to which the controller is subject. So in terms of payroll, for example, in order for you to legally process payroll and keep the required HMRC records up to date, it will be necessary to take certain employee information, including bank account details and NI number. So that would be your legal obligation there. It can be lawful if it's taken in order to protect the vital interests of a person. So, for example, the health records in a medical environment there. Lawful if it's necessary for public interest or official authority, so more so for the public sector there. And it'll be lawful if it's for the legitimate interests of a data controller or yourself, the employer in this case. And this is really where you can have a little bit more flexibility in classifying your processing. So for example, there, performance management records of an employee, you need to hold that information for a certain amount of time for the legitimate interests of you, the controller, to record that information. So again, as we've said there, unless you can kind of tick off one of those boxes in relation to the lawful processing, you really shouldn't be continuing forward.
Okay, so Jenny mentioned consent there, and I just want to go into a little bit more detail on consent because this is kind of some major changes with the legislation in this regard. So if you are relying on consent in order to process data, you need to be aware that there now is an elevated threshold for consent. And I suppose in terms of your business, you may need, one of the most common reason why people are relying on consent is for any marketing material that you may send to your customers or your clients. So that might even be in the form of your company newsletter offering certain special offers on a particular month, or Christmas offers or summer sales or whatever. That'd be the kind of newsletters that you might be relying on to have consent. So when we talk about consent now, consent must be specific, informed, unambiguous, and freely given. It must be for a specified purpose. So the one-size-fits-all options are no longer permitted. And I'm sure even if we've all bought things online and purchased things, and you get to the end of the page and you see the tick boxes that say, tick here if you'd like to opt out of our newsletter. So even that option going forward under GDPR will not be permissible. It'll have to be a tick box that you actively tick in to say, yes, I do want to be included in the newsletter. The second point is where consent is obtained as part of a larger document covering other things, consent text must be clearly distinguished from everything else. So if you have a 5-page terms and conditions agreement that you want customers to tick at the end or before they purchase, consent for marketing can't be hidden in the middle of all of that. It must be, again, clear and identifiable to the reader. You also need to retain evidence as to how you got that consent. So for example, you have sample forms, you might have a brochure that people have signed up, or website screenshots if they're purchasing online. So that, again, that evidence has to show that clear affirmative action has been taken. And the onus, again, will be on the data controller to be able to prove that consent was given. And then finally, the language must be accessible. And this is kind of a theme that runs throughout the GDPR, is that your language and all your privacy policies that we talk about later on, it must be easily understood. So, no more legalese. And particularly if you are obtaining consent for those under 16, your language has to be suitable for them. So just to finalize there, I suppose, just because somebody is a customer, this does not mean that you can automatically add them to your mailing list to tell them about every special offer you have. They have to have opted in. So I suppose even in the case of ourselves here in BrightPay, and we will certainly, if you're a customer, we'll let you know of essential upgrades or essential maintenance on the software. But unless you have actively opted into our mailing list, we won't be sending you our newsletters or details of webinars, etc.
That just brings up quite an interesting point regarding the purchasing of mailing lists for use for marketing. And this is, our understanding is that the purchasing of these mailing lists is something that is going to be defunct in the post-GDPR world. So certainly we wouldn't be recommending purchasing any forms of mailing lists going forward.
Absolutely not. No, I don't think so. Okay, the next point, so the data controller, the data processor relationship. So this is an area where there's some key changes. Under current legislation, most of the responsibility to comply with data protection law will fall with the data controller. So if you're a company and you outsource your payroll to Payroll Bureau ABC, you, the company, have all the responsibility. However, under the GDPR, data processors now, so for example, your Payroll Bureau, will have more direct compliance and responsibilities. So as a data controller, there is an onus on you now that you may only appoint a data processor or use a third party, which provides sufficient guarantees to implement appropriate technical and organizational measures to ensure that their processing meets the requirements of GDPR. So again, if you're a small business and you're outsourcing your payroll, you need to be checking that that Payroll Bureau is taking steps towards GDPR compliance. And equally, because I know we have a few accountants and payroll bureaus on today, so if you are offering payroll bureau services, I really think you should be taking steps to notify your customers that yes, we're moving towards GDPR compliance and we're doing A, B, and C. Because they certainly use GDPR as an opportunity to advertise yourself rather than to lose clients if you're not prepared, really. And just a second point in relation to the data processor is that they are only permitted to process personal data in accordance with the controller's written instructions. So the relationship between a controller and a processor must be governed by a written contract. And this is really, really important. The GDPR also specifically sets out what must be in this contract. We'll talk about this contract in more detail later on, but it may be that you'll have to review the contracts that you have between you as a contractor or as a processor to ensure that those extra stipulations under the GDPR are now included in your contracts. And as I said, we'll touch on that in a little bit more detail.
Absolutely. So we'll take a look at the security now. So given the potential significant impact of security breaches, data security is addressed significantly under the GDPR. It contains both preventative and reactive requirements in respect of personal data breaches. The regulations state that organizations should have technical and organizational preventative measures in place that will A, help prevent a breach from happening, and B, minimize the impact should a breach actually occur. So we look first at technical measures. So one of the first things there would be the likes of pseudonymization, anonymization, or the encryption of personal data. Putting in place a process for regular testing and assessing the effectiveness of controls that you may already have in place. And then your organizational measures. So using an unsupported version of a program that you might have. For example, we'll take Windows XP there. Microsoft themselves no longer support Windows XP. So it would be prudent for somebody who uses that package to make sure that they have a supported version of it. It wouldn't be looked upon kindly if you didn't. And then avoiding unnecessary copies. So for example, there with a payroll bureau, if you've got somebody, or we did have somebody who asked the question where they had their payroll processor who was bringing the payroll home and doing it from home. This wasn't an issue for the company because obviously she was getting her work done. But once she left, you know, and her contract had ceased with the company had no way of knowing if that data was deleted. You know, so again, just avoiding unnecessary copies, or ensuring that, you know, if people are working from home, they're using work devices, things like that.
I think we could have a huge conversation around what the technical and organisational measures might be, and they'll differ depending on companies and organisations. They'll very much be specific to you, but we will go into a few more details later on. But just to look at the reactive requirements when a breach does occur, the GDPR introduces a duty on organisations to report breaches to the ICO, the supervising authority, and in some cases to the actual individuals who are affected by the breach. So we touched on a personal breach earlier on, but a personal data breach can be broadly defined as a security incident that has affected the confidentiality, integrity, or availability of personal data. In short, there'll be a personal data breach whenever any personal data is lost, if it's destroyed, corrupted, disclosed, if someone accesses the data or passes it on without the proper authorization, or if the data is made unavailable and this unavailability has a significant negative impact on the individuals. So in terms of reporting the breach, where a breach is likely to result in a risk to the rights and the freedoms of individuals, it will need to be reported to the ICO. So for example, it might result in discrimination, damage to reputation, financial loss, or loss of confidentiality. So these breaches will need to be reported to the ICO. In terms of reporting them to the individual, breaches that are likely to result in a high risk to the rights and the freedoms of individuals must be reported to the individuals. So the high risk here is the difference, and the high risk means that the threshold for notifying the individuals is higher than for notifying the relevant supervisory authority. Now, I can't give you a list of what the risks will be. They really have to be assessed on a case-by-case basis. But if you do have a breach, you will have to notify the ICO within 72 hours from the point of becoming aware of that breach. And failure to report the breach when required could result in a fine, as well as the fine for the breach itself. So a double whammy there, if you like.
Absolutely. And like, if you have a breach, let's say on a Friday, it's not applicable to wait until the Monday, the next working day, to report it. That 72 hours starts on the Friday.
Yeah, the clock starts ticking straight away. Absolutely. So in terms of preparing for this, you'll just need to ensure that staff understand what constitutes a breach in your business, and that you have an internal data breach reporting system in place. So for example, who is the person that makes that decision in terms of the final call as to whether or not you notify the ICO, and who makes the final call in terms of notifying the individuals. So if you are using a data processor, just a final point on the kind of breaches, if you are using a data processor as your payroll bureau, it will be a requirement, and the GDPR stipulates this, that it's now a requirement for them to notify you, the data controller, once any breach occurs. So regardless, we've set out here that the reporting to the ICO and the individual, but if you're using a data processor, they must notify you as soon as any breach occurs.
Absolutely.
So we're getting close to the end of our 10 changes.
Laura's just mentioned there the data protection officer. So just very quickly, the data protection officer is a new role that will come into effect with the GDPR. So the main role of the DPO, as we call them, will be to monitor internal compliance with the regulations. Now, for most SMEs, you're not necessarily going to need a DPO. It will be mandatory to appoint one for the likes of public bodies, organizations engaged in large scale monitoring, public bodies, things like that. It may be mandatory in other contexts, but again, the individual member state can kind of define that at a later stage. We kind of say that the DPO must have expert knowledge of data protection law. So for many companies, it's unlikely they'll have the skill set amongst their current staff, so they may have to recruit or outsource for it. And they must be involved in a timely manner in the discussions of the processing for personal data. So there's a couple of other things there. They shouldn't have any internal conflicts of interests, and they should be sufficiently senior to implement those obligations, because obviously they're going to be reporting to the kind of highest level of management. And as I said there, it doesn't have to be an employee, so outsourcing I think is going to be quite common. And a group of organizations can have just one DPO.
Yeah, perfect. It wouldn't be right for us to make a sweeping statement, but it would be our thoughts that for the most part for SMEs, who mostly who we have on today, would generally not need a DPO. But again, you'll have to just review what kind of data you're processing and if you need one.
Exactly.
Moving on to the individuals, the enhanced rights for data subjects. So individuals do have new enhanced rights under the GDPR, so are data subjects. So if you're an employer, these will be enhanced rights for your employees or your customers. So there's quite a few, so we'll take them one by one. So firstly is the right to be informed, and this emphasizes the need for transparency in how you use personal data. You must be very clear with the data subjects about how you use their data.
Absolutely. The next one then is the right of access. So this is where the data subject requests access to the personal data you have on them. There's a number of factors in that. So the time frame has been reduced from 40 days to 1 month with the GDPR. Fees have been removed. So I think at the moment, if a data subject requests access, you can charge them £10, but under GDPR that'll be gone. And you can refuse the request if it is found to be manifestly excessive or unfounded. An example of that might be where it's permissible to refuse a data subject if you've received an access request within a short time frame of already responded to a request.
Just an existing right that we already have is the right to rectification. So individuals are entitled to have their personal data rectified if it is inaccurate or incomplete. And then an enhanced right is the right to erasure, so also known as the right to be forgotten. And the broad principle being that an individual has the right to request deletion or removal of personal data where there is no compelling reason to retain that data. So if there was somebody on your mailing list and they have the right to be removed at any time, again, if there's no compelling reason to retain it. On the other hand, in an employment situation, it is more likely that you will need to retain some employee details if you were to comply with your legal obligations. So you have a compelling reason there.
The next one then is the right to restrict processing, but you would still have the ability to retain the information or the personal data. Then the right to data portability. So this allows individuals to move, copy or transfer personal data from one IT environment to another once it's done in a safe and secure way. This is quite commonly done within the banking systems.
And then we have the right to object to the processing of data. So again, I'm going back to my marketing mailing list here. At the time when you're getting consent for somebody to opt into their mailing list, you must also make it clear to them that they have the right to object at any point and can kind of opt out of that mailing list as well. So employees or individuals, data subjects, can object to the processing. And then finally on this, rights in relation to automated decision making. So automated decision making relates to any form of automated process intended to evaluate certain personal aspects of an individual. So it might be if somebody was going for a loan and loan approval was based purely on an automated decision process. So in a situation like that, the data subject has the right to request human intervention and to the right to express their point of view as well. So I just want to touch then, kind of an aside from our 10 points, is GDPR from a HR perspective if you have employees. So data in the employment context will include information obtained from an employee during the recruitment process, even regardless of whether or not they were eventually given the job. It'll also include information that you hold on current employees and previous employees. So you may have the above information saved in hard copy personal files and maybe on HR systems, but all the same concepts that Jenny and I have just talked about will apply to your HR files. The issue with GDPR and HR files comes to lawful processing and consent. Previously, we've all had a clause in our contract of employment that said your personal data will be processed. That's always been fine. However, now under GDPR, as he's already heard, consent must be freely given, it must be specific, it must be informed, and it must be unambiguous. So given the imbalance of power between an employee and an employer, it will be difficult for consent to be freely given, which means it's unlikely to provide a valid basis for processing HR data. So if we go back to Jenny's slide on lawful processing, when we talk about our HR data, we now need to decide, right, well, what are my lawful grounds for processing my HR data? Possibly the two main ones will be that final one that Jenny talked about was the legitimate interests of the business. You will hold some personal performance files, etc., because it's the legitimate business interests. Also necessary for the performance of a contract and to comply with a legal obligation in terms of paying an employee and meeting your employment contract obligations. So as an employer, you will need to give thought to each separate piece of employee data that you process, and you'll need to record the grounds for lawful processing. The next thing to be mindful of is that right of transparency. And with regard to the right of information, employers will need to provide more detailed information as to how and why they are processing HR data. So they'll have to provide that information to the employees. It's all about the transparency. And there's a long list of information that will need to be provided to employees here. But again, we'll touch on that a little bit later on. But I suppose just to kind of summarize some of the key points when we talk about employee data, firstly will be to be clear on the reasons as to why you are retaining it and using it. Secondly will be to amend or review your data protection policies and your employee privacy policies in terms of being transparent and clarifying to employees why you're holding their data. And then the final point, which is a really important point, is to consider that if you are providing data, in terms of providing it transparently, the GDPR introduces a new best practice recommendation that where possible, organizations should be able to provide remote access to a secure self-service system, which will provide individuals with direct access to their information. So you might consider whether or not you can provide some sort of employee self-service login as well. And we'll touch on that later on as well.
There's just one thing that comes to mind here is how long would you keep that employee data for? So there's obviously a certain amount of employment legislation that stipulates how long data should be retained for. So for example, your annual leave records, your maternity leave records, your payroll records. In other areas such as recruitment and performance management, employers have more flexibility to decide on how long they want to hold on to that data for. And again, referring back to that privacy policy, once you decide on your retention periods, they should be clearly set out in that employee privacy policy, which Laura's going to touch on a little later.
Just our final change then before we finish this section.
Yeah, so just very quickly then, the privacy by design and privacy by default are important new concepts under the GDPR. And basically the privacy by design requires organizations to consider privacy measures during the product design processes. So kind of right at the very beginning of setting up your establishment. Whereas the privacy by default requires controllers to ensure that by default is processed. So really, both concepts there is that the privacy should be embedded into the DNA of an organization. It really shouldn't be a second, or a secondary thought. It should be there from the get-go. The GDPR also requires formal data protection impact assessments, or PIAs, in relation to the higher risk processing activities. So as a data controller, if you propose to carry out new processing activity, if that processing results in a high risk to the individual, you will be required to conduct a protection impact assessment. High risk processing might include the processing on a large scale of, special categories or sensitive data, or large scale systematic monitoring of public areas, things like that. So the regulations will provide guidance on just exactly what needs to be included in that. So just to give you a quick description of it. So that's the 10 kind of key differences. So there's just a quick summary of the 10 of them that we've looked at. So we'll move on now.
Perfect. So we look at now how you can start preparing as a business. We've created a 7-step guide that we feel businesses should consider in terms of starting their preparation towards GDPR compliance. We'll look at each one of these in more detail, but to give you a brief summary of each one, we think the first step will be to complete an inventory of all the data that you hold and that's being processed. This will be a big step in helping your company become accountable, which, as we've seen, is one of the key new concepts of GDPR. So I suppose then, depending on the outcome of your data inventory, the following steps may vary in terms of how they flow, but I think they'll all still equally apply. The first one will be your employee preparation, so we'll talk about that. The next step will be your customer preparation. So you'll need to look at reviewing your privacy policies with customers and any contracts that you have in place with your processors or your data controllers. Capturing consent. If you are relying on consent as a legitimate reason for processing data, you'll definitely need to take a step back and take a look at how you are getting that consent and is it compatible with GDPR. Governance. GDPR is an ongoing thing. It's not just a one tick box exercise. So you want to develop a plan as to how you'll maintain GDPR compliance. Security. This is a big one. The technical and organizational measures that you're going to take to ensure breaches are minimized. And then the privacy impact assessments and data by design and default that Jenny has just spoken about. So in a nutshell, we think these are the key 7 steps that you should be taking.
Absolutely. So the first one we're going to look at is your data inventory. So as a first step, you should review all the personal data that you hold. So whether that data relates to current or former customers, current or past employees, unsuccessful job applicants, or other third parties. It has been suggested that examining all that personal data needs to be done under a couple of these, or under these following headings. So why are you holding that data? What is the legal basis for holding it? How did you obtain the information? Why was it originally gathered? Was it for a marketing mail shot from a listing? How long is the data going to be held for? How is the data saved? Is it secure? Do you have the likes of customer details on a post-it note? Do you have a bin beside the printer? We'll look at these a bit more now in a minute. Is the data shared and with whom is it shared? You may also want to consider if you process children's data or other special categories of information. The GDPR requires organizations to be in a position to demonstrate compliance with its requirements. So documenting the above in that inventory list is going to enable employers to be able to, 1, identify gaps in the compliance, 2, put in place processes to rectify those gaps and hopefully fix them, and 3, produce evidence of its compliance with the GDPR.
Yeah, we did this internally here as our own kind of BrightPay project, and we just used a simple Excel spreadsheet. It doesn't have to be something overly complicated. We broke our spreadsheet into marketing. We broke it into 3 different sections: marketing, employees, and any other customer data that we hold. And that allowed us then to kind of schedule around taking action in each area, and we just listed the headings at the top of the page. So again, it doesn't have to be an overly complicated project, but certainly what I would say, having gone through it ourselves, is talk to as many people in the company as you can, because somebody else is always going to think of, oh, but don't we do this and don't we do that? Certainly, so it's best just to talk, I suppose, when doing this.
Exactly.
Okay, the second point that we had on our to-do list was your employee prep. So we spoke earlier about the need to determine what your lawful reasoning for maintaining employee data will be. So once you've determined this, you'll need to communicate it clearly to your employees. And I see that going forward under GDPR, that employers will now have a new document that they will issue employees, and this will be in the form of an employee privacy policy. And in terms of the employee privacy notice, if you're a Bright Contracts user, you'll be familiar with our software, but we're almost finished finalizing a sample template for the employee privacy policy, and we'll have that available for you really shortly. Other policies that you might want to look at considering will be updating your data protection policy. You might look at having a clean desk policy, and this is something that Jenny spoke about earlier. And again, it's really, it's basic things. If you're an accountancy practice and people are going home, leaving client files on their desks, who has access to that? Would people who shouldn't be seeing that, being able to see that? And then working from home policies as well. The second key consideration that you should be looking to make is whether or not your business could accommodate that employee self-service option that we spoke about. And we spoke about earlier about how this is now a new recommendation for businesses under GDPR. So as we said then, I think it really would be prudent for all employers to at least consider the possibility of having an employee self-service. As you said, at the core of GDPR is that term of transparency and data subjects having easy access to the data that's held on them. So certainly a cloud offering would offer both of these things. So I want to just show you what, very, very briefly, a couple of slides before we go on to step 3 in the process. Just a couple of slides on our Connect product. Just very quickly, that's Bright Contracts. If you're a Bright Contracts user, you'll be familiar with the headings across the top. So we're adding in a new privacy policy heading there. But to move on, to move on to our Connect package, with the Connect solution, employees can log into their own secure portal, and here they have the ability to view most, if not all, of the information that an employer will hold on them. So you can see here on this slide that they can view their basic employee details with the ability to update these details if necessary. And if we were to think back to the rights of a data subject under the GDPR, they do have the ability to update their details if incorrect. So this can be really easily achieved through the Connect. And again, having it here in the portal, for me as well, it takes much of the responsibility off the employer in terms of ensuring your HR data is correct, and you're pushing it back on the employee to make sure they inform you if things change.
Obviously, if you're a payroll bureau, that's going to be an ideal situation because you'll be getting the information directly and not having to rely on the controller to give you the updated information.
Well, is that if you're a payroll bureau and the employee updates it, it feeds back straight to you.
Yeah, exactly, yeah.
And also, actually, just on the Connect here, you can see that employees can view their annual leave calendar and request leave through the portal. So again, an added benefit. If nothing else, that just saves time for employers. Just if I move then across to the Documents tab here, this feature here, and we're seeing a lot of interest here, is that employees can log on and view their pay slips. We were at Accountex in Manchester last week, and we were talking to a lot of accountants, and they were quite interested in this feature. So BrightPay, if you're a BrightPay user, BrightPay Connect links with your BrightPay payroll. So as soon as you finalize your pay slips in BrightPay, you can make them accessible on BrightPay Connect. So it removes the need to email pay slips. Now, I do want to stress here that under GDPR, it is perfectly acceptable to email your pay slips. There's nothing in GDPR that says you cannot email pay slips. But certainly you have to be sure that you have sufficient security measures in place, like encryption. Now, and BrightPay emails, pay slips are encrypted, but again, for some users, this is just an added benefit that the pay slips are available immediately on the cloud. And then just finally, also in the documents, you can upload any number of employee documentation, whether it's contracts of employment, probation letters, and again, employees can log in and see automatically what information you hold on them and what pertains to them. But we'll move back to our kind of preparation then into the next section, which is customers and your third-party agreements.
Exactly. So moving on to your customers, the first thing that you should be looking at in relation to your customers is your customer privacy policy. You will need to review your data protection notices and analyse whether they require any updating to ensure compliance with the new rules. And if you don't currently have any data protection or privacy policies in place, you really need to start putting them into place now.
Generally, you go on websites and you're down the bottom of a website at the footer, the black footer, they'll generally have a privacy policy there. So that's where you'll see examples of privacy policies if you don't have one already.
Exactly. So when you're collecting personal data, the GDPR requires businesses to provide detailed information to the individuals. That data could be from your customers when they sign up or book in with your business, and what information you need to provide. It's more detailed under the GDPR. So we've created a checklist of what information that you need to include in your privacy notice, and this is going to be included in a link with the email of the recording and the slides that will be sent either later on today or possibly tomorrow. So just to touch on a couple of the points that are included in that checklist. Transferring data outside of the EU. If you do or you intend to transfer an individual's personal data outside the EU, you need to ensure that approved transfer mechanisms are in place to do that. Now again, there's further guidance on that international data transfers on the ICO website. And the next point then is your data retention period. The GDPR does not specify any particular retention periods for personal data, and it does state that the personal data may only be kept for no longer than is necessary for the purpose for which it was processed. So when you're considering your retention periods, businesses really should be guided by the statutory retention periods. And I spoke of them earlier on. So the individual business needs and the data protection principles. Secondly, then we want to look at identifying your third-party contractors. So as we've already seen, under the GDPR, whenever a controller, so that can be your business, uses a processor, it needs to have a written contract in place. So if you as a business are transferring data to another company, for them to process that data, you will need to have a contract in place with them. So for example, if you have a pension scheme in place, you're obviously going to be passing on employee personal data to that pension provider or broker. And if you're using a payroll or a HR bureau provider, or perhaps you outsource part of your business, which involves you sending customer data to a third party. Now again, we've created a checklist of what must be in that contract between the controller and the processor. And again, that's going to be included in the follow-up email. We're currently finalising a template controller stroke processor contract that could be of use for the likes of the payroll bureaus, and we do hope to have this available in a matter of days, obviously as we're getting closer to the deadline. So again, if you're interested in receiving notifications as to when we have these template documents available, let us know. There's a survey at the end of the webinar where you can opt in to receiving our additional information.
Okay, so moving on with your prep then, the next steps as we see them would be capturing consent. So as we've already said, if you are relying on consent as a legitimate reason for processing data, then you need to take a step back and you need to look at how you are getting that consent and is it compatible with GDPR. If you have mailing lists that you've used pre-GDPR, you may not be able to continue using them if you haven't got specific approval from the individuals. And another point that you want to be aware of here is the point that where you are asking somebody for consent to process their data, you must make it clear that they can opt out at any time. And actually, it's just funny, we were in the kitchen here before we came out and I was chatting to one of the lads who told me he was watching the Man United match at the weekend, and on the ticker that is across the screen, they had a message to say, sign up to our mailing list. So even Man United are getting on the back of GDPR here as well.
I wouldn't say any of our webinar participants would have watched any of those matches this weekend.
Well, I certainly didn't anyway. Governance. So to move on to governance, under the governance heading, you want to develop your compliance methods to ensure that having put the initial steps in place, you can continue being compliant going forward. So this might include to review how you deal with a data subject access request. So if an employee comes to you and asks to see their data, how are you going to deal with that? Can you deal with it within the required time frame? Do you have the necessary process in place in terms of dealing with a breach? Who's going to make that final call? Decide in advance who's going to make the final call on reporting a breach if it happened. Decide, do you need a DPO? And update staff on data protection. This is a really important one, and you really should, this would be one of the first things that you do as well, is spread awareness of GDPR across your company, hold training sessions, explain to staff what would constitute a breach in your organization.
Okay, so again, just touching on the security aspect, we did look at it a little earlier on, but just in a bit more depth, you need to be reviewing your security protocols. You need to start considering the integration of the security measures that are specified under the new GDPR regulations. So the likes of your technical measures, that might include the likes of ensuring that that the PCs or the computers in your workplace are all encrypted, and that you have secure firewalls or antivirus programs in place, again, that they're up to date and they're monitored, that they're not an unauthorized package, and the likes of anti-spam software. It is really important, for example, the last 2 years, there's been a number of well-known brands that have had their customers or employee data compromised. The high-profile one in the courts at the moment is the Morrison's case. where a disgruntled employee released employee information of over 100,000 of Morrison's current workers. You've the likes of the TalkTalk case, Tesco Bank, 3 Mobile, Sage, Moonpig. So if you are holding customer data online, you need to be sure that it is secure. Organizational measures might include then having a clean desk policy. Now that might seem like a very simple task, but we have had questions from people where they ask, you know, I have a notebook on my desk, I keep a record of people who've called, their phone numbers, you know, NI numbers, things like that. Is it sufficient for me to close that notebook at the end of the day? That obviously is not going to comply with GDPR regulations going forward. So, you know, putting in place that, you know, documents that may have personal data are put away at the end of the day, locked into cabinets, you know, that simple things like having a secure Wi-Fi in place. So we have come across a case of a shop that offered, you know, kind of open Wi-Fi to their customers. And it turned out that their tills were on the same Wi-Fi network. So, you know, if anybody had had the kind of IT knowledge, could possibly have intercepted the data that was coming in on those tills. And obviously you've got credit card details of customers, you know, so simple little things that you might necessarily think of, you know, having a shredding box beside your printer.
Yeah, there's loads of them. We could go on all day. Just one more to mention is if you're dealing with credit cards, if you're taking credit cards as part of your business, PCI compliance, ensuring you're PCI compliant will be really important as well.
Then your privacy impact assessment, your data by design, data by default, you know, the implementation and the processing that you do for those, just again, review them all.
And if you do bring in a new process by which you're processing personal data, it may be kind of prudent to carry out a privacy impact assessment then.
Exactly.
Okay, so that kind of brings us to an end of how you're going to prepare. We'd like now to go through some steps with you as to how we at BrightPay are preparing as well. I'm delighted to say that today we have a cameo appearance from our MD, Paul Byrne, who is going to talk you through what we're doing here at BrightPay.
Okay, thanks Laura and Jenny. I must say it's great to have this sort of expertise in-house. I don't know what I'd do without them. Anyway, here at BrightPay, I suppose data protection has always been a concern, and we've always aimed to act with complete integrity in this regard. But like all companies in preparation for GDPR, we did have to sit back and take stock of what data we held, how we were obtaining that data, and how we were processing it. Now, I say data, I think the girls said data. It's a bit like tomato and tomato, yeah. So I have to say the process of going through all this was quite interesting. Looking at some of our processes, we realized that perhaps they weren't the most efficient, and we took the opportunity to improve how we do things. My own take on GDPR is that holding data has become something of a curse. Get rid of it as soon as you can. And while you do hold it, make sure you keep it as safe as possible and only hold it for as long as it is needed. For example, we don't hold customers' credit card details, and thank goodness for that. We do hold names and addresses of customers because we were obliged to keep these for 6 years. Otherwise, I would probably delete these details ASAP. I think the first thing to say is that BrightPay does not have access to your data files, except where they have been submitted for support reasons. We have no control over the authority, the quality or safety of the data input. You and you alone are responsible for the accuracy and completeness of your records. Whilst we have security measures in place to protect your data, it remains your responsibility to keep your sign-in details secret, to sign off from BrightPay or Connect or Bright Contracts product when you're not using it, and to ensure that there is no unauthorized access to your computer. Moving on to what we have done, I'd like to go through some of the key changes that we've made that will affect our customers. One of the key aspects that came out of our inventory list was that from time to time, when assisting an employer query, in order to fully resolve the query, the only solution for us is to request the backup of the customer's file. Whilst we did have security protocols in place for this, we felt that we could make them even more secure. So we've created an in-program support feature that allows users to automatically send a backup of their payroll to us through a secure channel. The benefits being that you don't have to upload the backup to your email where you may forget to delete it, but mainly on our side, the backup never gets saved on an employee's PC or email. It's all saved centrally on a secure server and then automatically deleted after 1 week. In our 2018 software, we've also included a new secure password recovery option. We've also worked on increased encryption of the data files just in case some hacker does manage to access your files. Next, we've updated our privacy policies, and these will be going live on our websites shortly. The new privacy policies make it clear to any individual whose data is processed by ourselves how we use your data, who we share it with, and how long we keep it for. Next, similar to what was said earlier, after deleting HR files, we've completed internally IT audits on every company PC, deleting any unnecessary data. Going forward, our plan is to run these audits regularly, as it's a great way for us to keep track of all the data that we hold and ensure that we're not retaining anything unnecessarily. We've looked at how information is sent to us and retrieved from our secure servers, be it for the purposes of maintaining our websites or our CRM system. We've now changed all our servers over to the more secure Microsoft Azure servers. We've also introduced IP whitelisting, meaning that just knowing the login credentials is not enough. The request must be coming from a trusted location. Next, we've introduced extra consent fields in different areas of the software and websites. Going forward, with the exception of essential software updates, customers will not be contacted unless they have specifically opted in. Although I would have to say that our newsletters and webinar invites are quite informative, so certainly say it's worthwhile giving consent. Internally, we have held staff training and update sessions to ensure our staff are fully aware of the new legislation and how it impacts their role. On our BrightPay support pages, we've uploaded a range of support documents to help you get started with GDPR. I suppose I know the girls mentioned BrightPay Connect earlier on, and I was quite surprised actually. Well, it caught me a little bit off guard that GDPR was actually quite favourable when it came to BrightPay. It's something we hadn't considered in designing BrightPay Connect, but it certainly ticks a lot of boxes in keeping you GDPR compliant, with employees being able to access their data and transparency and all that. So it's actually, in a way, it's been a good thing for us, even though it's been a bit of a pain as well. The other side of that, I suppose, is that we have to make sure that obviously the information we store through Connect on our secure servers is completely hack-proof, because it would be a tragedy if we had a breach and we had to basically suffer the reputational damage there. And finally, just a note here, if you're a Bright Contracts customer, we will be updating the data protection and privacy policies within the software over the coming months. Okay, so I'll just put you back to Laura here. Thank you very much.
Perfect. Thank you, Paul.
Thanks, Paul.
So that brings our presentation really close to an end, and I'm eager to get into the Q&As because there's quite an amount of questions coming in, and so that will be an interesting session. Just finally, before we finish up, please do, as we talked about newsletters, please do sign up to our newsletter if you would like to hear about more webinars, events, industry updates that we're sending out. And finally, thank you for attending, and hope you found it useful. We are offering a 10% discount on Bright Contracts for the next month if you are interested.
Up to the 13th of April.
Perfect. So bear with us now until we get the questions brought up, because I said there is quite a few.
Absolutely. So just give us a second while we try and get
Jenny's just going to
organised.
Yeah, I think we're just putting on our lovely camera now as well, which you get a joy of seeing us. So Jenny's getting the Q&As up, but I've just seen one that came in earlier on from Rachel, and it says, would it be a data breach to send it back up to BrightPay? Yeah, that's a good question. Hopefully Paul has kind of addressed that in his section as well, to say that we have taken steps internally here to secure our processes around taking in backups. What I would say is, the one point to mention, if BrightPay, if you are a payroll bureau and you're sending backup in to BrightPay, we then become a sub-processor for you. Now, we talked a lot about sub-processors in our webinar for payroll bureaus a couple of weeks ago, so we went into more detail there. But certainly, if we, there's restrictions or new regulations around sub-processors, and details of sub-processors must be in that data controller, data processor contract that we spoke about. So certainly if you're a data processor or you're offering payroll bureau services and you may from time to time send us in a backup, it's perfectly fine. We have security measures in, but we might suggest that you have a look at our template contract once we release that, as I said, hopefully next week, because we have some wording there that would just kind of help guide you with your clients.
Okay. I've one in there from Lorna. As a very small bookkeeper, I will always take data protection, or now GDPR, into account, but do I actually need to create new terms and conditions to send to my existing clients? And do I have to type up an official policy which shows my compliance? Also, could there be an audit from the ICO? Well, as Laura's just mentioned there, the contract, the template document, I think will be of use to you, Lorna.
Yeah, there's increased information that the GDPR now requires you have in your contract. So whether you issue a new contract or you add an addendum to your existing contracts, you will certainly would be recommended to put something extra in place. So was the end of it there. Could there be an audit from the ICO? Absolutely. They have the ability to do dawn raids if needed. We very much have to wait and see how they will approach it. I don't know whether they'll wait till there's a breach and then, investigate somebody, but they possibly could come in and do an audit. But I would imagine for the small employer, you won't be kind of first on their list.
No,
that said,
bigger.
Yeah, that said, you don't want a breach, because if you have a breach or somebody reporting a breach about your company, well, then they're going to certainly come and look to audit you.
It's kind of my impression as well that the whole GDPR was more to try and deal with the likes of Google and Facebook, but we've all just got caught up in it.
Yeah. That's where kind of it originated, and we've got our first slide. We're saying it's about the Googles of this world and the online services, but then it's had a knock-on, trickle-down effect to the smaller employer, I think.
Yeah, but the reason for that is obviously that the legislation hasn't been updated since 1998. So, I mean, we all use our phones for internet usage and God knows what else. So, it did need to be updated, really.
There's just another question there about the fee to the ICO. Is this the fee that we currently pay, or is it an additional fee? It's the fee that you currently pay. There's no additional fee under the GDPR, but you still have to pay the old fee if you like.
Would a solicitor's and accountant not dealing with clients or staff payroll need to comply? This is a question that comes up quite a lot, and people may be under the impression that, if they've got a certain number of employees, it won't apply to them. But once you hold personal data, so whether it be your customer information, employee information, employees that you may have interviewed a number of years ago, if you hold any personal data that identifies an individual, you need to comply with the new GDPR regulations.
There's another question there. Could you touch on the issues for the processor and controller? What is needed where we are outsourcing payroll, and what should we expect from the processor? What does the processor need to have in place? Okay, well, the onus, as we said earlier, is on the controller to make sure that the processor is able to guarantee they have significant, go back to this phrase again and again, technical and organizational measures in place to protect data. So what they might be will depend on the different organization, but in terms of if it was a payroll bureau that you were outsourcing to, do they encrypt their email payslips? That's the kind of thing you want to be checking. But I think the main thing that you want to do here in terms of the processor controller arrangement is to update your contracts. And as I said, we have a contract template almost ready to go, and certainly have a look at that once we get that out next week. We'll hopefully have it and let you know.
Is it possible to clarify why a computer IP address would be classed as personally identifiable and therefore covered, as the computer is not an individual and can be used by anyone?
That's the answer. We don't know why they've classified that.
Yeah, it's been specifically listed, and it is a new addition. It wasn't under data protection, the current legislation, but it has been added. I guess it could be that only one person uses that computer.
That IP address, yeah. Is a disability under special category of data?
Well, health records are under special category, but certainly From an employer perspective, you will be required, because there's legislation in terms of health and safety and being able to comply with health and safety legislation, and also being able to protect the vital interests. If we think back to our lawful reasoning for processing data, to protect the vital interests of an individual. So you will be, if somebody has a disability, you will be required to hold some medical information on them. And the same goes in any kind of employment. You know, you will hold some health records for individuals, because you know, do they have a disability, or you'll have some sick notes, and that's fine. It's just, again, ensuring you have that included in your privacy policies and you make reference to it.
And the next two questions are similar. So will we still be able to send payslips by email? And can you touch on paper payslips posted to employees or sent by courier to a branch office? There's nothing in the GDPR which states you cannot email or post your payslips. Once you are seen to take those technical and organizational measures into account and ensure that, you know, kind of as many security measures have been taken to provide security on the pay slips, there's no reason why you can't do it. Obviously, BrightPay encrypts everything, and there is a facility for password protection on the email pay slips. With regards to posting pay slips, there probably isn't too many companies doing it, but I suppose if you register, post them, or, you know, again, once you're seen that
mark it strictly private.
Exactly, yeah, you're seen to be taking those measures to ensure the security, then it's perfectly fine.
And sometimes when I look at the, you know, the questions of paper forms, I think we'd probably all be going back to paper forms. The problems we have with holding data. Yeah, no, I haven't seen any issues with that. No. Security pay slips is another thing that a lot of pay slip software does, which, you know, basically it makes it very difficult for anybody to see, well, apart from just the name.
There was one about an iPhone. If we give our staff an iPhone with fingerprint recognition, can we allow them to choose whether to use fingerprint entry? Yeah, I think that would be the...
Yeah, well, you have the option on the iPhone.
Yeah, I wouldn't make it compulsory, but it could be an option. And if people were happy to do it, and also just to make it clear to them that if they change their mind at any time, that'd be fine, and there'd be no detrimental impact of them opting out, I suppose, if you like. Do filing cabinets need to be locked at night? Well, if they hold personal data, I would suggest they should be. That would be your organizational measures.
Yeah,
certainly.
It's like your clean desk policy. Yeah. How long would a small business have to retain data related to clients and data related to personnel?
Well, the legislation never stipulates how long you have to hold data, and that'll be up to a business to decide how long they need to. I think you'll have to follow kind of guidance from different pieces of legislation in terms of keeping your employment records.
There's company law, there's revenue guidelines as well, or HMRC guidelines. So generally, you have to keep records for up to 6 years. If it relates to your prime books of entry or the books of record that you use to prepare your statutory accounts and stuff like that. So you do actually have the statutory obligation, which I believe overrides any GDPR consideration.
Yeah, absolutely. Yeah. So then if you were decided to hold on to that data for anything beyond those 6 years, I think you'd really need strong reasoning to do so. And then in terms of, again, there's lots of different employment legislation in relation to your employee files where annual leave records are kept for 3 years.
Payroll records
for 3 years.
Yeah.
So you just be guided by the individual pieces of legislation. So nothing specifically set out under GDPR.
Yeah, like I know it's even just from a practical point of view here, like we have a new, we have a CRM system which we introduced probably 4 years ago, and we're fine in that the information that's on that is required legally for us to hold in case we have an audit or whatever. But once that system becomes more than 6 years old, we have to work out some way of actually extracting information that we no longer required to hold, which is going to be a major sort of exercise. We're going to have to get the programmers in to write some sort of script that will basically delete out the old information or obfuscate it. Do you think that's the other thing?
Yeah, kind of anonymize it in some ways. Yeah. Consent, is that the next one? Will this be required? So will consent be required even if we are a bureau and only act for the employer only? So again, we're going back to the lawful reasons of processing data. If you're processing data as a payroll bureau, you're probably going to be relying on something else other than consent. You're going to be relying on the contract option and the legal reasons. So I don't think you really would need consent there. It would only be then if you were sending out a mailing list, a newsletter each month, that you'd need consent.
If using a hosted solution for payroll, bookkeeping or accounts and tax returns where the data is held on the host's servers, but I update the data and the host does the backups, who is the processor?
I think what you need to, we all use this to a certain degree, even, you know, if people are using Dropbox to save information, that's a host server. And essentially, we talked about what is processing data. Processing data can simply just be holding data. So it will be possible that these will be in some way a processor. Now, small companies aren't going to go and put a full contract in place with the likes of Dropbox and Google. But what you should be doing is just taking some steps to check that you've checked Dropbox or your whatever this host server is, and check that they've taken steps to be compliant with GDPR. And that could be going onto their website, checking their GDPR pages, checking their privacy policy, and then just in making a note of that. And we see in terms of becoming compliant for GDPR is that you almost have your lever arch GDPR folder, and you in here you document everything that you've done towards compliance and all the checks that you've made.
Exactly. Accident and medicine forms at a nursery. I assume the question there is, you are holding personal data. You would have a certain amount of the children's information there. You're dealing obviously with children and under 16s. You will need specific consent from the parents in relation to that. And I would imagine the likes of a nursery, you're going to have some kind of contract or agreement that the parents have to agree to. You would just need to make sure that that contract is very easily readable to them, and that you include in it the information that, you know, if there is an accident or medicine has to be administered to the child, that they have to give you explicit consent to allow them to do that. But there's a lot of information again on the ICO website in relation to those kind of special categories and the underage as well. So Sadie, there's no harm in having a look on the ICO website too.
Next question, I don't know if I would understand this properly. When you mentioned lawful processing, does this mean just saving and storing data within your organization? Well, processing, as we said, could mean anything. It could mean, you know, working on a payroll file, looking at an employee HR file, or even simply storing it, or taking in customer, if you're taking a hotel booking and you're taking in customer data. It's any kind of personal data, and you have to have lawful reasons. I don't know if I'm, do you interpret anything else in that question?
No, that's the way I would read it as well, yeah. As a small bookkeeper, can I store clients' paperwork within my home if I am using or working on it? I appreciate that this is now classed as a risk.
There's nothing in the GDPR that says you can't, similar to emailing payslips. It's just you have to be sure that you are taking the necessary precautions in terms of, again, the organizational measures. So it might just be you, whether or not you would let employees do that, because could you track that information? That's really a decision you have to take internally yourself, and be able to, once you make it, be able to stand over and ensure that you may take it home, but you've got parameters around that. Or if you're bringing it home, well, you've asked for paperwork, you know, a lot of people say if you're bringing home work on a USB key, that USB key would be encrypted. So if it was lost or left on the bus, nobody could access it.
Yeah.
Even just the files themselves within that USB key, if they're individually encrypted. Like I know if somebody saves a BrightPay file to the USB key, and say the USB key itself isn't encrypted, but to actually access the BrightPay file, they need a password to get into it. So
exactly, yeah.
And without that password, the file has encrypted personal information such as NI number and names and things like that. So.
Exactly, that's the kind of measures you'd be looking to put in place.
Do we need consent to outsource payroll processing to a processor?
No, not necessarily. If as a business you are outsourcing payroll, you don't need consent from employees, but certainly what you do need to do is in your employee privacy policy, you need to specifically set out that we do outsource payroll and we're using a payroll provider A, B, and C at the moment. And if you are outsourcing pension or health insurance, they'd also need to be included, but you don't specifically need consent, but you need to make it clear to the employees that this is what you're doing.
What about the next level up? What about a bureau that will outsource, say their Irish payroll to another bureau who might be more proficient at doing that?
So the agreement there is between the bureau and the controller, so their client. So again, that goes back down to the controller processor contract. They would need to stipulate, that's a sub-processor, so in that contract they need to stipulate who their sub-processors are. So the payroll bureau doesn't need to specifically have a contract with the client's employees. That's all down to the client to put that in place.
But they would need to let their own client know that they're using somebody else to process the payroll. Yeah,
that's a big change in GDPR. It's this whole idea of sub-processing, and if you sub-process, you cannot sub-process without the written agreement of your client. And equally, if you are sub-processing, the onus is on you as the processor to ensure that that sub-processor is equally compliant with GDPR and that you have some sort of an agreement with them in place. Bit of a long-winded one. Where are we?
Yeah, it's on here. Yeah, okay. Just bear with us a second. There's quite a few long questions here. We'll
try. The question in relation to the rules still apply when we deal B2B, business to business. We don't deal direct to the public, but we have websites and newsletters. It doesn't really matter. My work email address will be laura@brightpay.co.uk. That's personal data. So it's not that it's laura@gmail, even though it's laura@brightpay, that's personal data. The only kind of one thing I would say around this is if you were sending an email to an address that might be admin@brightpay.co.uk, that's a generic email address. So that wouldn't be personal data. So you could certainly be emailing there. But business to business still falls under GDPR.
Do you need to add a statement on employee record forms to inform them of GDPR and that their information will be stored?
Yeah, absolutely. Yeah, that's a new employee privacy policy. I'd recommend that you're giving it to new employees and existing employees. Yeah.
How do the consent rules relate directly to employers and employees? Information is not for marketing purposes.
Yeah, so as we spoke earlier, consent is not going to really apply in the employer-employee relationship because we have that imbalance of power. So you're going to need to be relying on other reasons for lawful processing, and Jenny spoke about them. It's mostly about to deal with your contract. So you'll need, the Employment Rights Act sets out that you need a contract and certain information needs to be in that employment contract. So you'll be relying on that ground. You'll also be relying on the ground of for legal reasons. So I need to hold my employees' bank details. I need to hold their NI number because I want to pay them. I want to be compliant with HMRC. So they're the lawful reasons that you're going to be reliant on in the employment relationship. But again, you need to set them out and communicate those to the employees through your privacy policy.
We create mailing lists from publicly accessible information on local council websites. How will the legislation affect this data as it is publicly available?
But have you received have you received permission from that individual to now email them in relation to whatever it is? So if you want to email them about selling your product or marketing, you'll have to get their specific permission and their consent.
There'll probably be a change as well in that those sort of mailing lists will no longer be publicly accessible.
I would imagine
those local councils will have to up their game, I think, in relation to GDPR.
Yeah, exactly. Well, they'll fall under the same heading. They have to comply with the GDPR regulations. So having them on a public domain won't be permissible going forward, I'd imagine. Again, kind of a lot of questions coming in on the consent. Is it necessary to obtain consent from all our clients to hold personal data, as this is obviously required to complete the work we have been asked to complete? If you're the payroll bureau in that instance, or the accountant, again, I imagine you're going to have a contract in place.
It'd usually be a letter of engagement.
Exactly,
outlining the services that the accountant will provide. I think it's going to be part and parcel of this GDPR that we'll have to build in a paragraph or a section, and nearly a complete section to do with GDPR. And again, I think, as Laura said earlier on in the webinar, that's one of the things that we're actually working on getting together or putting together. So we'll hopefully have a draft shortly. And
yeah, that could be your guide, but you certainly need to be thinking about updating that letter of engagement with your clients. Yeah. Good question, the next one. If data is being collected on a child where the parents have live separately, will consent be required from both? I really don't know is the right answer. It might have something I'd have to double check. Consent will be required. I don't know, is it sufficient to have it from one or both of the parents?
I suppose.
Yeah, I don't know. I mean, I suppose
Better to be safe than sorry, maybe.
Yeah, but in the separation, I don't know if it's a court separation or whatever, there might be a ruling that one of the parents has responsibility for.
It's the main.
Yeah.
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 So I don't know.
Beyond our scope a little bit.
It is.
Okay, this is quite a long one. We keep a list of present and past clients, but do not use it for marketing, only as a list of past jobs for reference. Can we keep this electronically or print it out and start a new list? If so, do we need specific consent? These details will be in emails relating to the job. Do we need to delete those? Okay, there's quite a few questions there.
I think the general thing is you can hold them for the minimum of the 6 years that Paul referred to earlier, then going beyond holding data beyond that 6 years.
You have to have a legitimate purpose or a legitimate reason for holding it.
Yes, and I'm not sure if your reasoning here as just a list of past jobs for reference, that could possibly cover you for 1 or 2 years, but it certainly wouldn't be sufficient, I think, for beyond 6 years retaining that data. And in terms of how you store it, whether it's electronically or in paper format, I don't think there's really a difference, or there'll be.
Yeah, I know it's a very valid question, because I can see in a construction business, like you might have done a job for somebody 10 years ago, and now they're looking for maybe other work to be done, and you kind of want to know what the plans were, and what you're doing now or what you're quoting for now what you did before will have a very, very direct impact on that. I'm sure it's more than reasonable to hold that sort of information.
Absolutely, and
as long as you keep it secure.
Exactly, and Janet has said there, should we anonymise the plans for storage? I have actually come across that, where if after your statutory obligation time limit runs out, if you have a legitimate reason for having it, which, as Paul said, would be quite reasonable there, you would have to be seen to take the security measures to ensure that they can't be breached. So anonymizing or pseudonymization on that.
If you anonymize it, but you need to basically you will need to know who that client is when you retrieve that information from storage. So I suppose just to keep it secure, that's the main thing. But I think there is a genuine business reason for that.
I think what I'd be doing there is, that goes back to my customer privacy policy. So once you stipulate clearly in your privacy policy that you're holding it on to it you set a defined time that you think is necessary in your business, in your organization, and you clearly put that into your privacy policy, and you can stand over that decision, and you're consistent with that decision, then I think you'd have a strong argument.
Okay. Sorry, just bear with us. Will a lot of people are asking about, will the webinar be available to watch at a later date? So anybody who's registered will receive copies of the webinar and the slides. Yeah. A little later on today, or possibly tomorrow, along with our kind of checklists that we spoke of earlier on, and there's a survey at the end of the webinar as well.
Another question there: do all employers have to register with the ICO? There is a requirement to register with the ICO. It'll depend on what personal data you retain. But if you go onto the ICO website, I think it's along the right-hand side, there's a link to register here now. And what it'll do is it'll take you through a number of questions, and depending on your answers to those questions, it will then say, yes, you need to register, no, you don't. So it'll depend on your own situation, but certainly do go on to the ICO and go through that process.
Would it be a breach if a BrightPay snapshot of an employee file is released to the employer or his or her accountant? Well, again, as Paul's mentioned there, the snapshots or the backups from the software are already encrypted. And then on top of that, they need the software to be able to open and would require a password then after that. So realistically, it's unlikely that there would be a breach there, a high risk to the loss of information for individuals in that case.
But certainly in the course of your business, you may need to send a backup to your accountant of your payroll. So again, once you have the proper
authority, and it's part of your letter of engagement that you can
do this, and you can,
yeah.
It's a sub-processor, going back to that concept that we talked about. So once you've included that in your contract, and it's a necessary business need, it wouldn't be a breach to send a payroll backup. No.
I was going to say, if you send it somehow to the wrong person, I suppose then it is a breach, but it wouldn't be a breach with high risk, because it would be needed. You'd need passwords and that
encryption,
too. But you still probably need to report that to the ICO. That happened, would you?
Well, if you had determined that it wasn't a breach with a high risk, there was no high risk, then you don't need to report it. But what you do need to do is keep a record of it, keep a record of the breach and kind of your investigation into it and the decision as to why you did not report that breach.
And how to prevent it happening again.
Exactly, yeah. As an accountant, do we need a written agreement from employers to enable us to process their weekly payroll? Yes.
Yeah, that's a letter of engagement. Yeah, but again, say we'll be working on that in terms of the GDPR updates.
A data processor, is it?
Sorry. If a data processor notifies you that a breach has occurred, what is the client's responsibility then? Do we have to inform the customer of the breach?
Well, again, that will go back to the type of breach it is, and if there is a high risk to the individual, and it'll really have to be assessed on a case-by-case basis. Similar to the client will have to assess: do you feel that this breach is significant, or the risk is high enough that you'd have to report it to the ICO? But certainly at a minimum, you'd be keeping a record of the breach, you'd be investigating it, you'd be looking at steps to prevent it happening again. And possibly if the breach occurred on the processor side, you'd be looking at that relationship with your processor, and are they meeting their obligations under GDPR?
I mean, one of the things that's sort of striking me as well is that you probably need to make sure that your passwords are fairly strong. It has happened. I mean, some of the major data breaches that have happened in the States, I think Equifax was one of them. And I was listening to a podcast of that recently. And apparently, some of the passwords that were used on the server end of things like password 123, which is incredible. So.
And we get that on the phones as well, where the employer is setting the employee's email payslip password. It really should be from the employee, and it shouldn't be the one password for all employees. We get that in the phones as well.
Well, BrightPay has a facility to actually generate a kind of a strong password for you, which you can use that option as well if you don't type one in. Sorry. This one. If my client sends me emails containing purchases they have made, I'm a bookkeeper, should I suggest they use an app such as Dropbox in the event my computer receives a virus or is hacked?
That's probably a personal decision. If email is encrypted, you might think that's sufficient, or you might bring in a process that as soon as you get that email, you're saving the contents elsewhere and deleting the email.
Yeah, I would feel myself, because I was an accountant in my former life, that if you're getting purchases in, very little sort of sensitive information, I would think, generally in
purchases.
that sort of,
Yeah,
those listings or whatever. And
wouldn't be a major.
no, I couldn't see it being, no. And I suppose just to keep your computer maybe up to date in terms of, the operating system and antivirus protection, and even the likes of, antivirus protection is free generally now, because you can get, was it Microsoft? What's that one? Oh, I can't think of the name, but I mean, you can actually get your computer fairly well protected, and it doesn't have to cost you anything at all, really.
What about bodies who receive public funding, such as the Citizens Advice Bureau? Well, I think it's if you're processing personal data, it's going to apply to you. The only kind of one I would note is the DPO there. If you're a public body, when we talked about when you need a DPO, a data protection officer, one of the requirements is if you are a public body. So it may be a case that
you do require.
Yeah, I don't know the situation or how it's set up, but you certainly, I think you in this situation need to look a bit more in depth as to whether or not you need a DPO there.
Okay. A public body can be 7 councillors and 1 employee. The cost of appointing DPO would be prohibitive and would increase local tax significantly. It's a little bit outside of our realm, but again, if you're a public body, it is going to be mandatory.
Does stipulate that you would need one. Yeah. We've answered the one about the backups.
Yeah. Protect yourselves.
Sorry, Jason, we're just reading this one. We are a small management consultancy company. How will we protect ourselves, our business, as consultants in the case our clients ask us to delete or give them all the correspondence between us? Also includes. So how do you protect yourself if somebody asks for a subject, a client asks for all the information you hold on them, knowing that your own data is also included in those, so your own correspondence emails. I don't know, there is professional privilege in some companies. I don't know if that applies to law firms where they don't have to, but it would have to be if you have that professional privilege. Otherwise, you'd be very careful in what you're putting in internal memos.
Would it be reasonable? I think one of the things I kind of saw on the slides you had earlier on was the request to delete or the right to be forgotten or whatever it is that not required to be reasonable?
The right to be forgotten and the right to request something to be deleted would need to be reasonable, but the right to access information that somebody holds on you, an individual has a right to see all those files.
And ask for them to be deleted, or to ask them to be
asked to view them. I think the question here is purely just to view them.
It just has to delete.
Oh, sorry, apologies, and asked to delete them. Well, you can only delete them if you don't have another compelling reason as to hold on to them. And again, your compelling reasons will be set out in your privacy policy. So that's why it's really important to have your privacy policy. So if you have, say, we hold on to client data for 6 years or 10 years because of your business reasoning, then you wouldn't. I suppose, again, a lot of this legislation comes from the Googles and the Facebooks. And I kind of use the example of the dating website. If you go on and you're on the dating website and then a year later you've found the love of your life and you don't want to be on that dating website anymore, then they have to delete your data then. There would be no compelling reason as to why they would hold on to that data for any longer. If it's a client and you're in consultancy, it might be that.
I think you could have a professional body that you still have an obligation to report to, or you're responsible. Like I know in the accountancy, we keep working papers, and we keep them for as long as necessary because we could have an audit from the institute at any stage. They'll want to see those working papers. So I imagine the
that compelling reason will overshadow.
Yeah, I would say so. It's a minefield, isn't it? Yeah.
Well, the more you delve into the questions, it just opens up so many different parameters. For mailing list, if the email is for a company email, example j.smith@company.co.uk, is it outside the scope of GDPR and not required permission of individual as it is not personal? And can we send newsletters, please?
Once it's the individual's name, John Smith at company.co.uk, that's personal detail, because I know that John Smith works for ABC Accountants, so I can directly or indirectly identify him. When we go back to what's personal data, I can identify John Smith that works in ABC Accountants, and they're based in wherever they're based. The only business addresses, as we said earlier, that wouldn't fall under GDPR are those ones that are sales at ABC Limited, admin at
Info at.
Exactly, yeah.
And because you've asked there, can we send out newsletters, please? Again, you need the consent, or you need that opt-in facility to be shown for you to continue to send out your newsletters. The slides, an example of our policies, as Laura said earlier on, there is an amount of support documentation that we've uploaded in relation to GDPR on the BrightPay support documentation section of our website, brightpay.co.uk. So there's a number of kind of checklists and template documents there as well, but we are working on the template controller data processor contract, and that'll be available the next week or so, hopefully.
Just a good question has come in here. Can employers insist or agree in a contract that it is the employee's responsibility to keep their own personal information up to date? This is a really good question, and I would certainly recommend that in all employment contracts you do have a clause to state that employees should notify you if their information has changed, and so you should push a certain amount of the onus back on the employee. I don't know if you can put all the responsibility back if the situation was, and that we've had cases where there was a bank and they had sent a letter to an old employee address, and then the bank were held liable because it was their responsibility. So ultimately it is your responsibility to have the correct information, but certainly I would be putting clauses in place in my contracts to put the onus on employees, and it will certainly mitigate any kind of situation that might arise.
Somebody's asked there, we use Bright Contracts. Will you be updating the software to reflect the GDPR changes by providing wording, etc., for the company to use? We will be upgrading the software very shortly. There will be a new section on it for the employee privacy policy, and new kind of sections within the handbook and sample documents as well are going to be uploaded. So that again is being worked on at the moment. So in the next couple of weeks we will have an upgrade for that.
Will new consent need to be obtained for data that will continue to be stored and shared that was collected prior to the 25th of May? Yes, it's all data, it's going forward. So even like to use the example of ourselves here at BrightPay, we would have had a mailing list that we mailed to people about webinars, newsletters, etc. So that we'll totally delete that email, that mailing list prior to the 25th of May, unless people have specifically opted in. Otherwise, we delete it. It feels a bit of a shame having grown it, but unfortunately, that's the legislation.
But you'll probably notice, and I've noticed myself, my emails first thing in the morning are full of kind of newsletter requests, people that I may have signed up to previously now looking for my explicit consent to continue receiving those newsletters. So you'll start noticing these things, as we said there. One of our colleagues in the kitchen mentioned about the GDPR on the Man United match on the sideline. It was in their billboards coming up. So you'll start to notice these things now the closer we get to it as well.
You might even get one of those from us.
Yeah, if you haven't already. Can you obtain consent verbally, i.e. if somebody rings in and asks you about something and in the course of the conversation you sign them up? Yes, there's nothing in the GDPR that says you cannot take verbal consent. Now again, it does say that you should have proof where possible. So again, if I go back to ourselves, for example, if we are processing an order over the phone, one of the questions will be, would you like to sign up to our newsletters? So in order for us to be able to prove that we have taken that consent, we've added it into our policies, and we can document the training that we gave staff to show them this process. So we've put in as many controls as possible. to prove that we are asking this, and it's, we would have recordings, but you might not have recordings, and that's fine. So I would just say verbal acceptance or verbal consent is fine, but be able to kind of build or show as many examples of proof as possible.
Mm-hmm. What can employees change and amend on the Connect portal? So employees, if they're on the BrightPay Connect, have access to all of their personal information. So their name, their address, date of birth, email addresses, so any of that information that you hold on them.
They won't be, it's locked down. They can't change everything. They can't change their NI number, nationality. They can change their name and address and basic information.
Yeah, phone number,
yeah.
I think one of the, I suppose this only relates to employees. One of the things we have coming up shortly on Connect is the ability of, say, the employer to enter the hours of their employees for feeding through to the bureau or through to the desktop software automatically. I suppose that's not the question that was being asked.
It's interesting. Actually, we had that question yesterday, so
okay.
You answered that.
I suppose the other good thing about the Connect thing as well is I think you were showing the demonstration that at least under the documentation section, they can see at any stage that the company handbook, they can see the contract of employment, providing those things have been uploaded, and any other documents that you want to upload in relation to that employee. So the employee always has access. It's totally transparent. They can ask you questions as the employer at any stage if something's wrong with the information contained in that documentation. So they mightn't be specifically be able to change details related to their contract or the handbook on the portal, but at least they'll be able to inform you if something's wrong.
And there's just a kind of a question that ties into that. And what are our responsibilities if our staff do not have access to the use of internet? So as we said earlier, it's only a recommendation to provide a self-service portal where you can. And certainly it'd be nice to do if you can, but if employees don't have the internet, you don't have to provide the portal.
No. Who is responsible for keeping employee information up to date? If employee doesn't inform employer of change of address or email, who is to blame if something goes astray?
I think we've kind of just answered that. The ultimate responsibility is the employer, but certainly to help mitigate some of your responsibility would be preferable to include a clause in your contract.
Exactly. Can you still post out payslips to employees' homes? Yep. There's nothing in the GDPR which states that you can't email or can't continue to post payslips once you're seen to take in the security measures to provide security on them.
Next one probably best for you, Paul, but are BrightPay payslips automatically encrypted? I think we've answered that. Yes, they are automatically encrypted. You don't need to select any other option when you're sending them. And equally, once they're sent from our servers, they're automatically deleted, so they're held for a minimum amount of time as well.
But I think the payslip itself needs to be password protected.
Yes,
Yeah. If it's not password protected, well then, if anybody else has access to that email, they'll be able to click on the PDF and it'll open. So it won't actually be encrypted in that case. But the transmission mechanism
is
encrypted.
Yeah. The password, again, we've touched on it briefly. The employee generally will dictate what the password should be, because obviously they have to enter the password when they receive the PDF document via the email, or else use the feature on the BrightPay to generate a password, and then you'd have to inform the employee.
Yeah, I mean, informing the employee as opposed to make sure that communication itself is secure. How do you do that? Just give them a little envelope, a sealed envelope with the password. I don't know.
You're running yourself altogether.
Said local self-destructive.
Well, we could go to all ends here to.
I think the word reasonable has to be used, whatever's reasonable.
Yeah, but hopefully it's just a one-off in basically communicating the password. Either the employee tells you what password they want to be used, or you inform them what the password that was automatically generated has been used. But it's a one-off, and I suppose just make sure other people don't have access to it when you're doing it.
We are working with a lot of freelancers and pay them via bank transfer. We keep their bank details with our bank in an online banking. Does it mean we need to send them consent forms for storing the bank details, or is there anything else that needs to be done? I don't think, again, you need to consent, because you're not relying on consent to pay this person. This is part of your contract with them or your legal obligation. So there's no need for a consent form, but generally when you go with a freelancer, you might be putting in place a contract
anyway.
Yeah, so I would just be, again, setting out my privacy terms and what data I hold on the individuals in my contract with them.
I'm just quite conscious of the time aspect here. There are still a huge number of questions coming in, so just bear with us.
We try to get to as many
minutes.
as we can. If we don't, apologies. Sorry, where are we now?
Okay, this one here. Would you be able to confirm or clarify that GDPR only applies if you are selling, supplying business to individual, and does not apply if you are dealing business to business? I think Laura's answered this one as well.
It does apply to business.
It does, yeah.
Can you please let me have the template for payroll bureau? Yeah, for the contract between the payroll bureau, that'll be available, as you said, hopefully next week. We'll make that available.
There is a question actually on the survey at the end of the seminar. If you do wish to receive it, just answer tick yes or tick the box for the request for that on the survey.
Question about P45s.
I think in the 18-19 softwares.
For the P45s to be sent by email. Yeah, as far as I know, that's going to be, I'm not sure it's going to be the first release, but it'll be,
I think, yeah,
an upgrade during April, as far as I know.
Sorry, the question there is BrightPay don't offer P45s to be sent by email. Can this be built into the email encryption system? We're currently obviously testing our 18-19 software at the moment, which is due for release, I think the 21st.
Next week.
Next week, yeah. So that P45 email facility, I don't think it's going to be on the original release, but hopefully on maybe the second or third release, it should be on it.
Next question has come in. I have a file of all our customer accounts that they fill in. Included in it includes customer name, address, registration number, and their contact details. Would it be required to be filed away now, as I keep it on my desk? I would recommend that you do file it away and keep it securely. So we talk about the secure technical and organizational measures. You need to be sure you're kind of putting them in place, and I would question whether it is secure lying on your desk out of hours.
Do these new laws only apply going forward, or do we have to get permission from people whose data we currently store?
I think we've answered that.
We've answered that, yeah. Sending backup files to BrightPay for review. What consent is required? What if contractually payroll data may not be provided to a third party?
That's a clause. So what if contractually payroll data may not be provided? So in that situation, are you saying your client has refused to permit you to send on payroll data to a third party? We've made reference to that in this template contract, and you'd have to try and discuss with your client, is there any other reasonable way around it? Explain to them why. Our template clause allows for the termination of a contract, because if it's something that you need to do, that would be the worst case scenario, but hopefully through agreement, and you would look at all reasonable options with your employees. The worst case scenario would be a termination of the.
Yeah, I'm not sure.
If I understood that question right?
I'm not sure. I think what I gathered from it is that sometimes we do get support calls where the customer is not in a position to email us on the backup or to send the backup through the normal sort of secure system that we have.
Okay.
And in those cases, we usually come to facilitate them by using TeamViewer. Yeah. Maybe to log into their own computer, so we don't actually have access. We don't have direct access to their information, or we can't download it or anything like that.
But again, for us to do that, we send on an email requiring specific consent.
Consent to use TeamViewer.
To use the TeamViewer on their machines, yeah.
Yeah, but normally we would be able to get around a situation where they're not allowed to send us in a backup.
Okay.
I think that's what the question is about.
Yeah. The There's quite long questions, so just bear with us a second. And again, we'll try and get through a few more just before we finish up.
Who is responsible for data retention, the controller or the processor? Well, both parties will have an obligation to retain their own records. We get the question, we've got it a few times, that if the controller decides to move on from a process or change payroll bureau, our understanding, does that payroll bureau then need to retain the controller's records? So I think that the onus, a general understanding is that the onus is on the controller to keep the records and not the processor. So you would have to, obviously, once you have handed back your payroll records to the controller after they left, it would possibly be okay to delete them. But I suppose maybe there's some more accounting or payroll obligations that you might need to. So I think both parties will have an obligation to retain.
I can just imagine like a revenue official turning, or a HMRC official turning up with some company, and the company will be able to say, well, actually, we don't have any records whatsoever because we had to get rid of everything.
Yeah. Well, yeah. How much does it cost to have access to Connect?
I suppose that's how much does BrightPay
Connect cost?
Yeah, well, basically a single employer, it's £49 plus VAT for a year.
And then we have bundle pricing if you are a bureau.
Yeah. All of the information, via our products is on our website. So brightpay.co.uk, brightcontracts.co.uk, and the support documentations that we have on the websites as well are is vast in relation to the software itself. And BrightPay Connect, you'll find information on the brightpay.co.uk website there. Okay, again, a lot of these questions are quite long and quite specific to the individuals asking them.
Natalie, we might come back to your question separately because it's quite a long one.
It's quite a long one, yeah. Okay, I think we'll just take maybe one more before we finish up. Here's a good one. Is there any plan to have a cloud version of BrightPay which can allow payroll bureau to run the payroll from any PC subject to license, password, login?
Okay, I suppose that one's for me, is it?
Yeah.
Well, look, it's something we do. I suppose it is on our roadmap, but it's a few years down the road, and the reason for that is generally when you have software on the cloud, it's quite basic. It doesn't have the same levels of complexity that you can have with desktop software. And BrightPay, even though a user of BrightPay may see it as quite simple and straightforward, there's layers and layers of complexity to it that is really only suitable at the moment for operating through desktop. But having said that, I know a lot of companies will have BrightPay sort of installed on maybe a hosted desktop or on a server or whatever, where effectively it is available to everybody who, say, within a practice, if they're working at home or whatever. So there are ways and means around it. Even just keeping the files in a Dropbox folder means that it does have the additional backup of being in the cloud environment. And then we have the BrightPay Connect, which is that does allow the employees to log in through their app or through the website or whatever. But at the moment, I suppose, in answer to that question, whether the actual software itself will be on the cloud, watch this space. I mean, it's another 2 or 3 years away at this stage.
Okay, I've just realised some of the questions that we're reading out of came in almost an hour ago. So apologies if we didn't get to all questions, and there's a lot of repetition now at this stage, so I imagine we've answered many of them that have come in. But what we do at the end of our webinars is we will collate all the Q&As, and we update an FAQ section that we have on the website. So we will do that if we haven't got to anybody, but I think just conscious of the time as well, that we'll call it a day for today. Thank you all very much for attending. I hope you have found it informative and aren't too scared about what's ahead. But as I said, we will fill out the questionnaire before you finish off, because It's great to get your feedback, and equally let us know if you're interested in getting those policies once they're ready to go. And other than that, thank you all very much, and thank you, Jenny. And
Thank you.
Thank you.
Thank you.